A mobile home purchase turns into a courtroom battle filled with missing payments, disputed interest charges, and a family fighting to keep the roof over their heads. The plaintiff claims the buyer stopped paying nearly a year ago and now wants the property returned immediately. But the defendant insists she has already invested around $15,000 into the home and believes she's actually entitled to receive the title, not an eviction notice. As the judge begins digging into the paperwork, confusing contract language, questionable interest calculations, and conflicting financial records quickly take center stage. With thousands of dollars on the line and children still living inside the home, this case is far more complicated than it first appears. Stay with us because every new statement raises another critical question about who is really telling the truth.
Sure, she's complying with the terms of the lease with the mobile home park, as my client is listed on that lease and could be in potential jeopardy if she were to face any eviction action against them or from the mobile home park. There's concerns about unauthorized occupants, utility payments, those things. So at this time, my client is simply asking for the defendant to be removed from the property so he may reclaim his property.
So we don't know whether lot rent is current or not?
No, my client has attempted to reach out to the mobile home park manager to get that information, and he was not successful. They did receive information from, I believe, the utility company that they were behind in payment as well.
All right, you said she purchased the property directly from the park.
My client did, the plaintiff.
Oh, the client, okay.
Yeah.
Ms. Patil, Mr. Fenwick is here late to his own party, so I'm glad that you waited. We'll address that in a moment. Ms. Mauser, what's your position here?
The last I knew, we were already in court in another county under case 20-D04-2105-SC-000745.
All right,
in
I
which
lost you. So you're
that's
in another
court.
county.
Yes.
That's incorrect, Your Honor. There was a pleading filed by my client. He's a resident of Indiana. He filed for legal relief down there. That case was dismissed as the defendant indicated she was going to start complying with the terms of the purchase agreement. So there's no pending other litigation at this time.
What county was that in?
What county was the Indiana case?
Elkhart County.
It was, no, the Indiana.
Elkhart County.
Elkhart County, Your Honor. But that has since been closed.
All right, is Mr. Gooden there with you?
Mr. Godwin.
Yeah. All right, so apparently that case has been dismissed. They're indicating that no payment has been made since.
The courtroom takes a dramatic turn as the defendant reveals her side of the story. She argues that she has already paid nearly $15,000 toward a trailer that originally cost just over $12,500 under the purchase agreement. According to her, the seller keeps changing the numbers and adding fees she never agreed to pay. She insists the contract never created a traditional loan with yearly interest and believes she should already own the title. At the same time, the plaintiff argues that no payments have been made for many months and that he remains legally responsible for the property. This is exactly where contract wording becomes critical, because even a few unclear sentences can completely change how thousands of dollars are calculated. What do you think so far? Is this a misunderstanding, or did one side misinterpret the agreement from the beginning?
The purchase agreement that I have, because I have a purchase agreement that doesn't have the interest on it. But if that's, another thing is I don't owe APR. I never signed an APR. This was not a loan.
Well, I have one here. It's a purchase agreement for $12,500 with 9% interest.
Right, that's $1,125.
Yeah, 9% interest, not per month, just 9% interest.
On the
$290 due on of each month. And that agreement was entered into in 2018. And there are going to be issues in here. Let me see about late fees. $25 late fee. All payments that are made more than 21 days late will be charged an additional $50 late fee. I would not allow a $75 late fee on a rental agreement.
But I can show you right here. This is the copy I have without the rent agreement or without the interest. I
All
don't know
right,
if you
all
can
right,
see
well,
that.
slow down here. There are often two sides to every story, and there are here. So for one thing, he is terminating your tenancy, but it's failure of a purchase agreement. So he's asking essentially to get the vehicle back, but in this case, the titled property, which is a mobile home. Your rent for the lot is with the park.
Right. And it's
You're
not-
also contending, all right, well, after you got served a notice to quit on February 8th, did you communicate at all with the plaintiff?
The last time I reached out to him, I just let him, he did say he messed up on a lot of the numbers at first, and he said he was going to fix those numbers and get back with me, and I have yet to see anything of a change of numbers.
Well, all right.
I talked to you, wasn't?
Just a minute, Mr. Fenwick,
Yes.
you're late. I'm staring at your ceiling fan, which is giving me vertigo, and you're talking while we're in court. So
I wasn't aware you could hear me. Sorry.
So just sit down for a minute. I will get to you here shortly. All right, well, the bottom line is I have to continue this matter. You could greatly benefit from some advice from legal aid.
Now the emotional side of this dispute comes into focus. The defendant explains that she originally obtained the mobile home while escaping domestic violence with her children and says this has been their family home since 2018. While her personal circumstances add significant emotional weight, the judge makes it clear that the court must ultimately decide the case based on evidence and the written agreement. The judge also notices that the purchase contract appears to be poorly drafted, making it difficult to determine exactly how interest, late fees, and outstanding balances should be calculated. Instead of rushing to judgment, the court recognizes that key financial questions remain unanswered. Sometimes the biggest courtroom battles are not about whether payments were made, but about whether the contract itself clearly explains what both parties actually agreed to.
With interest of 9%. What does that mean? And normally I wouldn't allow a late fee of $25 plus $50. So we've got issues regarding that. So we don't know how much is principal, how much is late fees, what is the actual interest. If your version is correct, that it's 9% one-time deal on $12,500, we're going to have to know how much you've actually paid.
I believe I attached account payment log, Your Honor, and
You did,
okay.
which is helpful, but I have to fly spec it. Yeah, he's adding interest each month. This is a poorly drafted purchase agreement.
And it's not
And-
the same papers that he issued me last time. They're completely different numbers.
Well,
Again,
this
that
one
case
is
is closed,
signed.
Your Honor.
Excuse me, Jordan?
Just, she keeps referencing a case that's already been closed. It's not relevant to today's hearing.
Well, it might be if he files something which says something different in the state of Indiana than what this says, it could be relevant.
The
But-
Indiana case was dismissed on consent because she agreed to start making payments again. So she wants to go down that road. I suppose we can at the next hearing, but he just is asking for his property back. He's not been paid in almost a year.
Yes, and her contention is she's paid the whole thing off and he won't give her a title. But I haven't added those numbers up. All right, well, we've got to move this, obviously. The law requires I adjourn it at least 7 days, but I'm going to need someplace to park this.
It's 13.
Rather than issuing an immediate eviction or declaring either side the winner, the judge decides the case needs additional review. The court concludes that the purchase agreement contains serious ambiguities regarding interest, late fees, and the actual balance still owed. Before making a final ruling, the judge wants a complete financial breakdown so the evidence, not assumptions, determines the outcome. This hearing serves as a powerful reminder that unclear contracts can create expensive legal disputes years later, leaving both buyers and sellers facing uncertainty. The final decision will depend on accurate records, proper legal interpretation, and whether the payment history supports either party's claims. Who do you believe has the stronger case after hearing both sides? Share your opinion in the comments below. If you found this courtroom battle as fascinating as we did, don't forget to like this video, subscribe to the channel, and turn on notifications for more real courtroom breakdowns and legal analysis.